Today on Off the Clock, we'll be discussing the growing trend of employees requesting religious accommodations to be excused from DE&I training.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
What we're talking about today is really about human interaction and more so conflict, right? And when HR can be caught in the middle of that, specifically when it has to do with the growing trend of protecting sexual identity, sexual orientation, and gender identity in the workplace.
Okay.
And individuals who would like not to hear about that in the workplace because they allege that it violates their sincerely held religious beliefs.
I see. Title VII against Title VII. So to speak, yeah.
Exactly.
Fascinating. We wanted to talk about this because we've had lots of phone calls and questions about it, and that's exactly right. And I think our listeners probably are aware that both the U.S. Supreme Court and the Michigan Supreme Court, along with many other states, have ruled that both sexual orientation and gender identity are protected classes, right?
Right. I don't think we can claim that as breaking news. But Sarah, as we learned, right, with this last Supreme Court session, sometimes court precedent can be overturned.
Right.
Right? And those protections are not written in Title VII and in the Michigan statute just yet, right?
They are not. Although, should mention the Michigan legislature is currently working toward changing the law itself to include it.
Right.
Which would mean that it doesn't matter what a court does or says going forward, though the law would be the law until it potentially is amended again. Right?
And there are certainly other states, right, that are moving the same way, and then local municipalities around the country that have their own protections.
Right. So suffice to say, sexual orientation and gender identity are both protected, right?
Yep.
Under the law now, which means, of course, that employers need to take steps to make sure that discrimination and harassment in the workplace don't occur with regard to sexual orientation and gender identity. And one part of that is that we're seeing an increase in employers doing DE&I training that includes conversation around sexual orientation and gender identity.
Right, that's exactly right. And then when you combine that with the growing awareness that employees have of the possibility of religious accommodations.
Right, yes, we saw a lot of those, right?
Yeah,
yes.
We saw a lot of those during COVID, right? So now people are more familiar with the concept. And I don't know about you, but in my practice, I am seeing an increase in requests from employees to be excused from DE&I training if it includes discussion of sexual orientation or gender identity.
I see, right? So, and that's fascinating, right? This intersection of what people learned during COVID about their right to request religious accommodations. You and I kind of saw this coming, right? That many employees became educated about something that they maybe hadn't given a lot of thought to, and that is they can assert their religious beliefs and rights in a way that might require the employer to make an exception for them to a policy or a requirement or a rule, right?
Yep, absolutely.
And we saw that broadly used, for example, with regard to vaccine mandates, sometimes masks in workplaces, et cetera, right? So this is kind of, we have lots of employees who now understand this that maybe didn't before, and we're seeing it carry over now into a different area, and that's DE&I training.
Yes, and you can imagine when that request for an exemption comes in, the conundrum that the HR office feels, right? Yeah. Really between a rock and a hard place.
Well, yeah, because they're, I know HR folks pretty well, and I know that there's nothing they want more than to make sure they're doing things right under the law, right?
Yep.
And so what I hear you saying is, on one hand, they have employees who have rights on the basis of their gender identity and sexual orientation. They've got rights not to be harassed or discriminated against in the workplace. And there's a desire to make sure we protect those rights, right?
Correct.
But then at the same time, we have employees who also have rights.
Yep.
They have rights to religious accommodations in the workplace. Man, that is a rock and a hard place.
Yes, and just imagine the EEOC, Sarah.
Oh, yeah.
So they're in the
Great
same
point.
similar position, but elevated, right, from our HR professionals, because they are in the business of protecting the employment rights of individuals, regardless of sexual orientation and gender identity, as well as protecting individuals with sincerely held religious beliefs from having to compromise those
Yeah, that's a
beliefs.
great point.
So they have actually wrestled with this. This was pre-COVID. As I said, in my own personal practice, I've seen the number of requests increase. But certainly, this is not the first time we've seen these requests. It dates back, the case law dates back some 15 years ago.
Okay.
And the EEOC has actually included a discussion of this specific issue in their guidance on for employers on how to deal with requests for religious accommodations. So it's very interesting. And
Yeah, what do they say?
so I have my reading glasses on.
Stand back, right?
We've been doing the show for
Listen
a while
up,
now, and you
listen up.
folks will notice
We've aged
that I didn't used to have my
know
reading glasses on.
in the last few years. That's right.
So I'll read you their guidance, and then we'll go through some examples.
That would be great.
So spoiler alert, a lot of it has to do with undue hardship. So let's see what they have. Let's see how they set out the standard,
Okay.
how they work through the undue hardship example, and then
Okay.
we'll go on to another factor that employers
Okay.
also have to consider. Okay, here's what the EEOC says, word for word. An employer is required, absent undue hardship, so bookmark
Okay.
that, we're going to come back to that, to excuse an employee from compulsory personal or professional development, training, or participation in an initiative or celebration
Oh, okay.
where it conflicts with the employee's sincerely held religious beliefs,
All right.
observances, or practices. There may be cases, however, where an employee can show it would pose an undue hardship.
All
You
right.
see, this is the
I
EEOC's
get it.
focus. Is it an undue hardship or not? To provide an alternative training or to excuse an employee from any part of a particular training, even if the employee asserts it is contrary to their religious beliefs to attend.
Got it. So the first thing I hear, and I think this is important, the first thing I hear is that there absolutely can be an obligation to provide that religious accommodation. In other words, HR
Yes.
folks should not out of the block say no,
Correct.
right?
Yes.
Because we want to have a certain, even though their motives for doing so might have sound basis, they need to take requests like that seriously, and they need to understand that there's a legal analysis to be applied.
Yes. And
Okay.
so some of this, people remember back to COVID vaccine mandates, right?
Right.
So remember with the mandates, employers needed to consider requests for religious accommodation. Doesn't mean they have to grant them,
Right.
but it has to think it through. And it's-
Engage in the process.
engage in the process.
Okay.
And one of those steps is the undue hardship analysis, because as the EEOC points out, and as we've discussed many times,
Many
related to
times, right.
the vaccine, if there is an undue hardship to the employer, the request does not have to be granted. So we're going to go through some examples of
Yeah,
undue
that's what I was gonna
hardship
say,
from the
right.
EEOC and lower courts when it comes to the specific issue. But before we do that, I mean, the whole issue of undue hardship in the world of religious accommodations is really exciting right now.
It really is.
And why?
I mean, to us, right? It's
to
exciting.
nerds, it's exciting.
It's exciting, right?
Yes.
So just a reminder for our listeners, for religious accommodations, that hurdle to show undue hardship is easier for employers as compared to disability accommodations,
Correct.
right? You only have to show what? For
Any
religious
inconvenience that is more than de minimis.
Okay, so that's a very low threshold,
Yes.
right?
Yes.
There is currently, right, uncertainty in the legal world as to whether that standard will remain the same or whether it will become a higher standard like we see with disability accommodation, right?
Yes, that's because the Supreme Court,
The U.S. Supreme Court.
U.S. Supreme Court,
Okay.
thank you, has accepted a case, will be deciding a case in the present term, which ends in October. So sometime before October, they'll be deciding a case about what that standard should be for an undue hardship analysis in a religious accommodation context. That case involved a postal carrier who asked for a change in schedule or to be excused from working Sunday because that was the employee's Sabbath. And it was a sincerely held religious belief that he would not work on his Sabbath on Sunday. The post office turned down the request for an accommodation because of the impact on his colleagues, right? Because someone has to
work
deliver
on Sunday,
on Sunday. Frankly, that scheduling issue, it can be sketchy, but yes, they were on relatively firm ground. The Supreme Court is going to decide whether the bar for employers should be higher. Justice Gorsuch and others have indicated strongly they believe it should be higher. So hold tight on what's coming with that. And now I'm going to blow your mind.
I'm ready.
I shouldn't have set it up like that. Now your expectations are too high.
They are high. I'm ready, though.
Curb your expectations just a little bit. The decision, the change in the standard could be retroactive.
Well, that does blow my mind.
So when we're talking about today, employers making decisions about religious accommodations today may want to apply a higher standard. This is something you need to talk to your employment lawyer about. Right? Because ever since the Supreme Court, they just accepted this case a few weeks ago. So this is new news. And that aspect of it, that it could be retroactive. So what do we do today when we're making those decisions is a new concept. And if you are struggling with a religious accommodation request now, this is a really great time to talk through the pros and cons.
Great reminder. And just to be clear, this is something that our listeners should be thinking about for all religious accommodation requests in general. So getting back to this particular issue.
Yes.
What would be an undue hardship? So, for example, is it an undue hardship if an employer were to say, well, it's really important that we have a culture that is accepting of everyone, including those with differing gender identity and sexual orientation, and so we think it's critically important that everyone attend this training?
Okay, so that was a loaded question. I'm not even sure if you meant it to be that loaded. First, I'll tell you what the EEOC has to say, and then we'll go to the courts. The EEOC says it can be an undue hardship to excuse a person requesting an accommodation if it's important for the employer to communicate the legal standards, what will and will not be tolerated in the workplace, and that discrimination, hostile work environment towards a whole host of categories and individuals, including the based on sexual orientation and gender identity. That can be an undue hardship because an employer does have responsibility to inform their employees of the laws and what will be acceptable and what will not be. We can do an instant replay with your question, but I believe you said we need to accept others, right? You used the word accept. Okay, so that was the kind of the trigger word for me. Because that might be crossing a line. We do not have a legitimate business interest in requiring our employees to accept the beliefs.
I see that difference
of others. Does that make sense?
Agree with.
Well, accept is could be another way of saying agree if it conflicts with their sincerely held religious belief.
That makes sense.
We have an interest in education. We have an interest in setting boundaries regarding behavior. But we do not have a legitimate interest in changing hearts and minds to the extent that that change could conflict with someone's sincerely held religious belief. Are you with me?
I am.
So if we think about the heart and the mind staying intact, right? But we can set certain expectations, we can train on behavior. And if HR and employers can kind of make that distinction, that would be very helpful in staying compliant with everything else we're talking about.
That's
okay?
That's really helpful.
So the EEOC provides an example, as I just said, that because an employer does have a responsibility to explain the EEO laws and what will be acceptable and what will not, it can be an undue hardship just based on that alone to excuse an employee. The courts have set a slightly higher standard. And again, after the Supreme Court decision, it might even be higher, but where it stands right now, the last case on this came out of New York. A New York
It's not
school.
surprising to hear because they have required training by law in New York.
That it is an important point where it happened, right? So New York requires EEO training, anti-harassment training, et cetera, by law for not just public employers, but every employer.
Multi-state alert, yes.
Yes, if you have an employee.
If you have employees in New York,
we'll come train them. So in New York, an employee made a request based on sincerely held religious belief that they not attend a training. It did not. This training did not ask them to accept or adopt a belief. It was merely what I would call, kind of base level training. Here is the law. Here are the protected characteristics. Here's what you cannot do. And the court said it would be an undue burden to excuse that person from the training because the law required that every employee
that the training occur. Got it.
And under the new, if the U.S. Supreme Court raises the standard, I still think that would probably pass muster. But most of us don't live and work in New York, right?
Right.
Even those living in New York, I know
That's right.
people living in Manhattan think that everyone lives in Manhattan. But there is a big world outside of New York City, and most employers do not have a legal requirement for training. So that's going to be, for the rest of the country, that's going to be a dicier issue if that standard gets raised.
I see.
So that's the undue hardship analysis. Okay, but that's only one side of this.
Right.
Right? What else do employers have to think about whenever they get a request?
Is there a sincerely held religious belief, right?
Is there
is this training, does it touch on that person's religious belief?
Yeah, is there a conflict?
Right, which goes back to your point, I think, about the content of the training is going to be so important.
It is very fact specific. Clients hate when lawyers say it depends, right? But when I've gotten these calls several times now, which is, should I allow an excuse or can I require this person to attend the training? My answer is, well, it depends. Send me a copy of the training.
Yeah, tell me what the training is.
And we'll look to see. Right. And so what the EEOC says specifically on this issue, if training conflicts with an employee's religious beliefs, the content of the training materials may be determinative in deciding whether it would pose an undue hardship to accommodate by excusing him or her from training or a portion thereof. If the training required or encouraged employees to affirmatively support or agree with conduct that conflicts with the employee's religious beliefs or signal their support of certain values. Signal their support. That's far less than agree with, right? That conflict with the employee's religious beliefs. So that is the difference, and there's several cases that follow that general line of thinking where the courts go, slide deck by slide deck, literally. And, there's a lot of training has click-through quizzes.
Right.
We have to look at
those are probably
not just the slide, but I tell clients I need to see the quiz.
Yeah.
To see what employees are being asked to confirm.
Okay.
At the end of the training.
So first of all, I guess I would just point out that there's currently nothing that proactively requires employers to have certain content to their training, right? All of this becomes relevant if and when somebody makes a request to not attend. Due to a sincerely held religious belief, right?
Mm-hmm. Yep.
But at the same time, some of what you're saying with regard to the content of the training strikes me also as things that HR folks might consider anyway as they're trying to negotiate these different interests and beliefs in their workplace.
right? Yes, for sure.
And so I'm hearing, right, an interesting legal conundrum, but also really from a very practical standpoint, as our listeners and HR professionals are developing DE&I training, they really probably want to be mindful of that line you're talking about, right?
Yes.
Education, focusing on conduct versus, on the other hand, trying to require employees to believe certain things or accept certain things that make them feel uncomfortable.
And as you pointed out off camera, that second category, which I'll just refer to as changing hearts and minds,
Right.
you're probably not going to be successful at as an employer or HR leader anyway, right? We spend our lives thinking about workplaces.
Right.
I mean, this is what we do for a living. Our HR professionals are so dedicated as well, but we do have to be realistic and humble.
Yeah.
Right? About our reach when it comes to employees and their belief systems. And it's not likely to be effective.
Right. If hearts and minds are changed, most of the time it's not because their boss told them something. Right? It usually is some other life circumstance.
My boss said it, so it must not be.
Yes, got it.
Yes,
got
you will
it.
get
got
resistance.
It. Well, that's really interesting and helpful information. Thank you.
You're welcome. Good to talk to you.
Good to talk to you. Have a great day, everyone.